Now, Justice Gorsuch wrote the unanimous opinion of the court, although several justices wrote concurring opinions. However, as is often the case with the Supreme Court, the question of whether or not the law violates the Constitution isn't based on the actual language of the document. Rather, the court based its decision on its previous decisions. To determine when the government infringes the Second Amendment, the court begins by asking whether the amendment's terms cover the conduct in question. If so, the Constitution presumptively protects it. This is from New York State Rifle Association versus Bruen. To overcome that presumption, the government bears the burden of showing its regulatory efforts are consistent with the nation's historical tradition of firearm regulation. The Supreme Court stated, in the case New York State Rifle and Pistol Association v. Bruen, that to overcome the presumption of constitutionality, the government has the burden to show that their regulations are consistent with the nation's history and tradition of firearm regulation. How does the federal government claim such consistency? The government construes 922G3 to automatically ban an individual from possessing a gun from the moment he becomes an unlawful user of any controlled substance and remains in effect until he ceases being one, regardless of what controlled substance an individual uses, in what amounts, whether his drug use has ever made him a danger to himself or others, why he keeps a gun, or how safely he does so. Remember, 922G3 only deals with controlled substances as defined by the Controlled Substances Act. By this logic, if you take a drug prescribed for someone else, you are now prohibited from owning or possessing a firearm. Now, how does the government claim this fits with our history and tradition in the United States? The government analogizes its construction of 922G3 to what it calls habitual drunkard laws, which it submits enjoys deep roots in the country's history and are relevantly similar to the regulation it wishes to enforce. Now, these habitual drunkard laws fall into three general categories: vagrancy laws that allow habitual drunkards to be confined in workhouses or jailed, civil commitment statutes that allow courts to appoint guardians for habitual drunkards or authorize their commitment to asylums, and surety laws, which, under the judicial office, could compel habitual drunkards to post surety bonds to ensure their good behavior. Oops. The government claims that habitual drunkard laws are analogous to 922. According to the court, though, none of these habitual drunkard laws actually prohibit the possession of firearms. The government's analogy fails on every metric it invites the court to consider. Taken cumulatively, these problems prove fatal to the government's prosecution of Mr. Hermione. The government's claim that historical laws targeted habitual drunkards for the same reason as 922G3, because they rarely use intoxicants, is difficult to square with the historical record. Around the time of the founding and for decades following, a habitual drunkard was generally someone who, for any considerable part of his time, was intoxicated to such a degree as to deprive him of his ordinary reasoning faculties. A regular or even frequent drinker did not usually fit the bill. The court even questioned the reasons behind the purpose the government claims behind 922G3. There are reasons to doubt that the government has established 922G3 even serves the purpose the government claims of disarming categorically violent and unusually dangerous persons. Section 922G3's reliance on Controlled Substances Act, a statute adopted to protect the health and general welfare of the American people, and under which drugs can be added to schedules for reasons having little or nothing to do with their potential to induce violence, makes it far from obvious that 18 U.S.C. 922G3 confines its reach to those who are categorically and unusually dangerous. If the government's purpose is to disarm categorically violent and dangerous persons, why did they use a law that regulates drugs, most of which have little, if anything, to do with people being violent or dangerous? Marijuana, which is the drug use that was the basis of Mr. Henry's conviction, has not only been legalized by many states, even the Department of Justice has directed federal prosecutors to limit the enforcement of federal laws against its use. It appears that the government's viewpoint that Mr. Hermani's conviction because his marijuana use made him violent or unusually dangerous simply falls apart.